Hi, I'm Jennifer Barnes, and this is my discussion on religion in the workplace and what impact that has on a manager. I feel this election year that religion has become a very hot topic. However, I also think most forget that the Constitution guarantees everyone religious rights, regardless of what religion they practice. My article is from the Anti-Defamation League. I chose it because it gives some outstanding examples of when companies have made decisions that have impacted employees' religious rights. The article points out that according to the EEOC, religious-based charges have increased by 50% since 1997, and the payouts have increased by 160%. So I feel it is something that each and every manager needs to make themselves aware of. The article is actually an outline guide to help both employees and employers understand their rights and also their responsibilities. The Civil Rights Act of 1964 addressed the issue of religion in the workplace. It stated that employers could not discriminate against an employee because of their religion in hiring, firing, or everyday work practices. But the most important thing that is often overlooked is the employers are responsible or required to have reasonable accommodations for the religious practices of their employees. Reasonable accommodations are the key. The article states that reasonable accommodations are one that eliminates the employee's conflict between the religious practice and work requirements, and it doesn't cause an undue hardship for the employer. These can include having certain religious day off, such as the Sabbath, the right to wear religious garb, place to pray. They give some ideas about having, people shift their swap their shifts, or have flexible scheduling, lateral transfer, or even using their lunchtime for getting off of work early. I know when I worked at Whirlpool, a girl had asked for Halloween off, was denied it, and said she needed it for religious reasons. When asked why, she stated she was a witch. The manager thought that was funny and ridiculed her for it, only to find out that she was a practicing witch and got both herself and the company in a lot of trouble. Employees cannot simply refuse to accommodate an employee. The employer must demonstrate the negative effect the accommodations would have, and that means that they have to prove undue hardship. One of the things that I really liked about this article, versus just stating things, it gives us some good examples. One is about a shipping company that refused to hire a Jewish man as a driver because of his beard. He wore the beard for religious reasons. The company required him to shave. So when they refused to hire him as a driver but offered him a lower paying position that would not have contact with the public, he was able to enact his Civil Rights Act of 1964, which requires the employers to make reasonable accommodations. The company felt that it would be in the company's best interest not to have a bearded individual as a customer preference. And it ends up being that that is not a valid basis for proving hardship. Another item was a restaurant chain fired a server because he had a quarter-inch wide ring of tattoos on his wrist. He considered these tattoos as part of his religious faith. When he explained his religion to the management, he was fired. The corporate meeting that resulted afterwards stated that the company had Christian values and the company wanted to have that all-American kid from the suburb as its servers. The company maintained that any changes to its dress code, including prohibitions on tattoos, would detract from its wholesome image and would be an undue hardship. Basically, the company is required to support its claim of undue hardship with more than hypothetical hardships, based on an unproven assumption about the image. Moreover, as noted above, customer preference is not a legitimate reason for not accommodating a religious need. There was another company where the employer was a certain faith. and she required her employees to read passages from her preferred religious text out loud at company meetings. She also offered paid days off for them to attend religious gathering and work closely to help those of her faith advance their careers. Any employee that didn't participate was penalized. Basically, it came out this is all wrong, that you cannot penalize someone for not participating in your religious faith, and you're not allowed to treat acceptance of religion or participating in religious rituals as conditions of employment, including advancing the careers or providing benefits such as days off for those who are not of the same religion. Another thing that was brought out is about how some people were teasing a Muslim employee about her headscarf. Even though she didn't object to the teasing and she continued to work productively, later on a manager began to criticize her wearing it. And as a consequence of this, he basically demoted her. And in a fit of anger, he grabbed a hold of her headscarf, tore it down, and in the process, knocked the employee to the ground. We all know that this would be considered a hostile work environment and would not be allowed. Another one was where an employee had to sign a workplace pledge concerning the tolerance of the difference because he believes it's immoral and against God's world to tolerate a homosexual. When the manager ordered him to sign a form, he refused and was fired. Basically, this goes in support of the employer. They had an obligation to determine whether his refusal to sign the pledge could be accommodated. Because they immediately fired him, there was no way to seek out what type of accommodations could be made. And so again, the manager acted in error. Another one was when an employee had a religious belief that required her to wear an anti-abortion button that showed a colored photograph of an 18 to 20-week-old fetus. The button caused disruptions in the workplace, and the employee's co-workers complained about the button. The employer basically gave the employee 3 different options, and when she refused these accommodations, she was terminated. Title does not require an employee to act on an employer to act on the employee's accommodation, what they want to have happen. They're only required to reasonably accommodate an employee's religious view. In this case, the workplace disruption and complaints and proof that the proposed accommodation were not accepted allowed the manager or employer to terminate this employee and still, keep within their Civil Rights Act. So it is very important as a manager for us to get a good grasp of what, reasonable accommodations are versus undue hardship. We don't want to discriminate against anybody, yet at the same time, we want to make sure that we protect our own interest of the company. Thank you.